Hi, this is Chapter 5 test review video. Direct and circumstantial evidence, both of them. Do they both require the jury to draw an inference in order to establish fact? No, only circumstantial evidence requires the jury to draw an inference to establish fact. Direct evidence does not require an inference. The jurors decide how much weight to give individual pieces of evidence. That's true. Jurors may consider the demeanor of a witness when assessing his or her credibility. That is true. The prosecution may introduce evidence regarding special skills the defendant possesses if these skills are relevant to the way the crime was committed. That's true. The fact that the defendant had the means to commit the crime is admissible as circumstantial evidence of guilt. That's true. Testimonial evidence regarding the defendant's efforts to destroy evidence is admissible as circumstantial evidence of guilt. That's true. The jury may infer that the defendant is guilty if he or she attempted to flee the scene of the crime. That is also true. Attempts to intimidate witnesses are admissible as evidence of guilt only if the witness filed a police report about the incident. That's false. So attempts to intimidate a witness are admissible as evidence of guilt regardless if the witness filed a police report or not. Character traits of the victim are irrelevant in a criminal trial. That's false. There can be times where it's relevant to the defense. The defense is claiming that never mind, that's a scenario. If a person has previously reported a crime to the police and it was determined that the person intentionally lied, it can be inferred that a more recent report the same person made to the police is also false. That's true. In a jury trial, the jury determines if a witness is telling the truth. The fact that the defendant has a graduate degree, well, this is a scenario of circumstantial evidence of ability to commit the crime. So if a defendant had a graduate degree in software design, that could be admissible in a case in which a hacker bypassed a company's security system and transferred money to a Swiss bank account. But that would only be if his degree establishes skill or technical knowledge to commit the crime. Then that could be admissible. That was just a scenario. Another scenario of circumstantial evidence of ability to commit the crime, if a defendant testified that it was physically impossible for him or her to have committed a crime because he or her had a bad back and could not lift the heavy object that was stolen, then jurors could infer that he or she is not guilty of the crime if that was believed. The jury is allowed to consider the fact that the defendant previously threatened the victim if the threat was made shortly prior to the crime and was very specific. The prosecution can introduce evidence that the defendant tried to conceal evidence as circumstantial evidence that the defendant is guilty. That's how it's introduced. Attempts to intimidate witnesses so that they will not testify in court in the defendant's murder trial are admissible as circumstantial evidence of the defendant's guilt at the murder trial. The fact that a person suddenly has a lot of money a short time after a robbery of a nearby bank and refuses to explain where the money came from does create an inference that the person obtained the money from the robbery. That's under circumstantial evidence of guilt. At trial, character is introduced by someone who is familiar with what people in the community say about a person in question. Evidence about the defendant's character is admissible at trial if the defense places character at an issue. So the defense has to first bring character as an issue, and then that defendant's character is admissible at trial. Evidence about the victim's character is admissible at trial if the defense is based on self-defense and the violent character of the victim is admissible. Evidence the victim has previously filed false police reports can be used to infer that the current police report was also false. So if someone filed a false police report before, that can be introduced as evidence, and it could be inferred that the current police report was also false. And finally, Under other acts of evidence, x-rays showing numerous broken bones and at various stages of healing can be used in prosecution of a parent for abusing a child to infer that the current injuries were not accidental. So that's inference for other acts of evidence. That's the end of the Chapter 5 test review.